So now let's move on to lesson 2. So lesson 2, it is the classification of evidence. So we're going to know the classifications of evidence. It is the ability to establish a fact in dispute of an evidence. First, we have the direct evidence. So what I have said, it is direct evidence is also real evidence or real circumstantial evidence. So direct evidence, it is the proof that the fact in dispute without the aid of any interference or presumption. So direct evidence, it is the proofs the facts only. Circumstantial evidence or indirect evidence, the proof of fact or facts from which taken either singly or collectively. The existence of particular fact in dispute may be inferred as necessary or probable consequence. We have here, there is more than one circumstance. The fact from which the inferences are derived are proven, and the combination of all these circumstances such as to produce conviction beyond reasonable doubt. Degree of value in establishing dispute fact of evidence. First, with the prima facie evidence. This evidence suffices for the proof of particular fact until contradicted by other evidence. It is the prima facie evidence. Second is conclusive evidence. It is the evidence incontrovertible or one which the law does not allow to be contradicted. It is insurmountable evidence. 3 is corroborative evidence. The evidence is different kind and character as the already given and tends to prove the same proposition. 4. Cumulative evidence. This evidence is of the same kind and character as the already given and tend to prove the same proposition. Weight and acceptability of evidence. Primary or best evidence. The evidence affords the greatest certainty of fact in question. Second, secondary or substitutionary evidence. The evidence is inferior to primary evidence and admissible only in the absence of the latter. The other types of evidence, we have the object evidence. This evidence addressed to the sense of the court and is capable of being exhibited to be examined or viewed by the court. This is also known as the authentic evidence or real evidence. Documentary evidence. It is referred to evidence supplied by written instrument or derived from conventional symbols and letters by which ideas are represented of the material in the substances. Testimonial evidence. This evidence is either verbal or oral. It is evidence which consists of narration or deposition by one who has observed or has personal knowledge of the which he is testifying. Positive evidence. This evidence is exists of witness. It is affirms that fact did or did not occur. It is entitled to the greater weight since the witness represents the personal knowledge about the presence or absence of the fact. Negative evidence. This evidence exists of the witness states that he did nor see or know of the occurrence of a fact, and there is total disclaimer of personal knowledge. quality of an evidence. First, we have the relevant evidence. This evidence is relevant if it has relation to the fact in issue as in those belief in existence of non-existence. Second is material evidence. This evidence tends to prove the fact in issue and determined by the rules of substantive law or the rules of the court. Third one is the admissible evidence. This evidence is admissible if it is relevant to the court or the issue and is not excluded by the rules of the court. Credible evidence. Evidence is credible if it is not only admissible evidence but also believable and used by the court in deciding the cases.